Okay, a very good morning to all of you. This is Vinakshi Singh. I'm a senior advisor with Indian National Bar Association, and I welcome you all for INBA's 9th annual international conference. And today, this is the second day of the conference. I'm sure we are on the new platform for Meet. It's a very good platform for networking. And I request you all to also go on the event page wherein we can keep messaging each other while we are on the call. Okay? Once the speaker is talking, if anyone has to say hello, hi, we can go there. Good? Are we all there? Okay, great. A very good morning to all of you. This is Vinakshi Singh from Indian National Bar Association, Senior Advisor. Today, I welcome you all for the second day of the celebration of 71st Constitution Day that we all are celebrating. And we had a wonderful sessions yesterday. And today, we also hope the same. It's a new platform for especially the students and the Indian lawyers who are joining in. So there will be connectivity issues. So let's check on that by going to the event page, and we can keep messaging there each other, whatever we have to say. And I welcome all 5 of you. And we have Mr. Montek Mayal from FTI Consulting. We have Miss Sindhu Sivakumar, we have Mr. Dheeraj Nair, and we have Ankit Kumar. We also have with us Apni Agarwal, a student member of INBA. So over to you, Mr. Montek. Please take it over from here. Thank you so much.
Thank you very much. I hope I'm audible to everyone.
Unmute yourself, Mr. Montek. We're still seeing mute on your screen. Unmute, it's auto mute. So if you'll have to unmute yourself.
I think I am on mute. I think.
Yeah, we can hear Montek.
We can hear you.
All right, thank you. So first of all, welcome everyone. Hope everyone is well and safe. It's a pleasure today to welcome you to today's discussion on Indian companies and cross-border disputes. We truly have an expert panel here with varied experiences and expertise, which we think is going to make for a great discussion. Very briefly, I'm going to introduce the panel and then kick off today's discussion and the topics we plan to cover. So first, we have Dheeraj, who's a senior partner at Sagar. He leads their disputes practice, and his core expertise is in making strategies and handling complex litigations and domestic and international arbitrations. Second, we have Ankit. He's the head of legal, secretarial, and corporate affairs at the Delhi office at Vedanta in their Sesa Goa iron ore and port division. Ankit has significant experience as a seasoned in-house counsel, corporate secretary, and a fraud examiner. He has managed end-to-end legal matters for corporates, strategizing and implementing legal and risk mitigation, contract management, corporate governance, and dispute management. Third, we have Vivek, a leading barrister from Essex, London. He acts as counsel and advocate in large-scale, complex, and high-value commercial disputes and investor-state disputes, including those involving Indian parties. Fourth, we have Sindhu. She's the senior investment manager at Innsworth Advisors, a qualified UK Indian lawyer, and she's responsible for originating claims, performing due diligence work, and active ongoing case management at Innsworth. I'm a senior managing director at FTI Consulting. I lead FTI's economic consulting and expert witness practice in India, and my primary area of focus is assessment of quantum, financial, economic, and valuation issues in contentious matters. We'll also have Suharsh join us in the second half of the panel discussion. Suharsh is a partner at AZB, focusing on insolvency, bankruptcy, and restructuring matters. And he'll have some very valuable insight in the insolvency regime in India and how that might interact with disputes and use of third-party funding. So with that introduction, now I'm going to straight head into our panel discussion for today. So Dheeraj, I'm going to ask you the first question to get the ball rolling here. what and then, of course, the theme of today's session is corporate Indian companies, cross-border disputes, and market trends. So, with that in mind, what are the type of disputes are you witnessing in the sector, especially in the last 12 to 24 months, and perhaps also which are the sectors where you are seeing the most activity in terms of disputes?
So, Montek, first of all, thank you for that introduction. So, going back to the question, I think one of the things that we've been off late seeing, and I don't know, is it a post-COVID effect or the reason that it was already brewing up before COVID started, is a lot of shareholders' disputes, which is primarily the foreign companies who have invested into Indian companies here or have joint ventures here. There is a lot of disputes that we are seeing per se. And in the last 6 months post COVID, I personally have started at least, I've been advising at least six companies, all of them on the foreign, I've been of course being instructed by the foreign companies. So a lot is happening on shareholders' disputes. There are exit strategies being made. There are disputes which are carrying on both at the NCLT level as well as starting towards arbitration, be it LCIA, SIAC, or ICC. Uh, and the other thing that I've been seeing over the years, over the months now, is a lot of companies, especially investors, are showing a lot of interest in doing forensic investigations and audits into the working of the Indian company. Uh, this again, as I said, is a process which has started just about when COVID had started, and it is kind of gaining a lot of steam now in terms of companies wanting to do a kind of a forensic investigation. So these are the two areas that I've been seeing a lot of spurt.
Yeah, no, thank you. And in just follow up on that, and you mentioned shareholder disputes, of course. And is there any particular jurisdiction, especially in terms of the cross-border investments and disputes, are you seeing? Is there a particular jurisdiction or
Montek, sorry,
can you hear me now?
yeah, I can hear you now. Sorry.
Okay, so I just have a follow up to the question, to the answer you just gave, and particularly in the context of shareholder and joint venture disputes you were mentioning. Are there any particular sort of corridors or jurisdictions which are seeing perhaps more disputes? So, in the context of India, any particular geography from where you're seeing more investments and disputes come from?
Not really. If I were to look at in just your previous question on sectors as well as particular jurisdictions, I don't think there is a kind of spurt in activity from one particular jurisdiction. So we are seeing, I'm seeing at least where I'm advising Japanese clients, I'm advising of US clients, I'm in fact a German client.
Yeah.
So it's not as if it's centered in one particular jurisdiction or a particular sector. So we are seeing disputes of the chemical lines, automotive lines. There is airline which is happening. So it's kind of varied and across sectors as well as across jurisdictions.
Okay. No, that absolutely makes sense. Thank you. Now, Vivek, this coming to you, and bright and early for you in London right now, so welcome. But any other thoughts you want to add to what this Dheeraj said, and specifically, I'm sure all of us and the audience is interested in on the UK India corridor. What are you seeing on that corridor, and what do you think Brexit might mean for disputes arising in that corridor?
Yeah, thanks, Montek, and thank you to INBA for having me here. I agree with Dheeraj. I think, in terms of the disputes that I'm seeing, obviously you have the sort of business interruption disputes, those claims, the insurance force majeure and all that. But there is another sort of stream of disputes, and that is the sort of recalibration of the business relationships, where you see changing priorities, changing objectives, and you will see, as Dheeraj said, more shareholder disputes, more JV disputes. I'm seeing a lot of government-related, contracts and transactions changing, and it's and here the actor is both the government as well as the sort of private party. And as far as the government is concerned, what's often said, that there is a regulatory chill and the government is not acting. Governments all across the board have become very hands-on. So you'll see more regulators acting, more regulatory actions being taken. Sometimes even regulatory investigations and sanctions happening. and a lot of disputes happening on the back of that. In terms of the sort of sectors I'm seeing, obviously energy infrastructure, what I do is very active. But a trend that I think started before COVID and continues is, banking and finance and life sciences. And the other one where I see more disputes coming up is climate change, which is, in different forms, be it environment related directly or, some policies. And I think that is something I'm seeing both on the commercial side as well as the investor state side. In terms of UK, India, and Brexit, I think UK's relationship with India is increasing and is going to increase even further after a proper Brexit. A Brexit actually taking place, but when a proper sort of Brexit takes place, when the EU agreement is no longer there, the Indian investment has gone up, and I think UK is very keen to have deeper economic ties with India because of the Commonwealth connection. And I think we will see more disputes on that gateway, but it's going to be both investment into India as well as investment into UK.
Yeah, yeah. No, I think that's again. I'm hoping I'm audible and not mute again. But I think that makes a lot of sense. So, in terms of climate change, you mean the ESG sector, which is also seen now, I guess, a lot of investments coming in, right? You mean the larger ambit of environment, social, and corporate governance issues, which are becoming quite relevant. Is that fair to sort of expand into that category, the larger category?
Yes, and I think the other sort of aspect of climate change is the various regulations that are coming. I think in India as well as abroad, and with now a lot of Indian companies having overseas operations,
Yeah.
this is becoming an issue that they're increasingly dealing with. And sometimes it happens directly in terms of environmental regulation, and sometimes it's in terms of something related to resources,
Yeah.
be it in the mining sector, but there is a concern about environment. And sometimes it is, environment being used just to sort of push protectionist agenda of the government. So I think both things happen, but increasingly it is something that is coming up.
Thank you. Perfect. No, that makes a lot of sense. Dheeraj, coming back to you a little bit. So we know obviously it seems to us shareholder joint venture disputes are a common theme. Possibly supply contracts, given especially the disruption we've seen in times of COVID. What are the considerational issues that come up in such disputes? So in the shareholder activity, what kind of disputes are you actually seeing? What kind of issues are being hotly contested? And for foreign companies investing, especially in India, and I know you do a lot of that work as well. What often has gone wrong when they've made investments in India?
Montek, the way I look at it is each dispute is obviously very peculiar in terms of what it means to a particular partner. So, for example, the most of it I think relates to either an exit value, which is kind of determined, or the expectation of an investor when they kind of invest into the company. And sometimes over a period of time, that kind of value which they had thought of, which they would probably get from that investment, hasn't come true, and then starts the blame game, right? And mostly because these companies are situated in India, the management typically happens to be either promoter driven or the Indian partner driven management, and therefore typically it's about how the business has been run, how certain decisions were not correctly taken, how the business could have done in a better way. So those are the issues that normally come up. Besides that, I think interpretational issues are also happening, where something like a non-compete, for example, right? There are obligations of non-compete on the foreign investor, and the foreign investor today sees opportunity to either come directly or link with somebody else, and then the Indian JV partner seems to have a problem with that, and then the entire issue of non-compete comes in, and of course the age-old dispute of the call and put options, which continue to happen all the time. So these are typically the areas that I'm seeing, in fact, in terms of the disputes that's happening.
No, I think that's very consistent with my own experience as well. Vivek, anything on that point you want to add before I move on to the next of the game?
I think I will have to completely agree with what Dheeraj said. Uh, what I tell international clients when they're investing in India is you need to understand some of the cultural and market aspects which are peculiar. Now, India being a very dynamic market, but there are cultural aspects, there are aspects how the market behaves, and as the Dheeraj also said, often there is a mismatch of expectations, which couple of years down the line, when you're looking at things in a pure dollar term, there is a dispute. Sometimes it plays out in terms of the expectation. Sometimes new lines are being added, and then the Indian venture partner is not very pleased with the fact that they're hobnobbing with the competitors, or who they see as competitors, and why they're not continuing with them. And then obviously you have the options of exit. And I think once a foreign company develops a proper India strategy, they're very keen to get in on their own, which again causes a lot of heartburn with the Indian side of the venture.
Yeah. So I mean, here one question to you before I want to then go to Ankit and get the corporate's perspective on this. But are you so obviously one question that often comes up in cross-border arbitration and disputes is a the arbitral process itself, or are the courts are going to interfere, not going to interfere, and B, of course, the enforcement issue, like once the award is out, how receptive is the jurisdiction where you're based, or the way you want to enforce the judgment to arbitral awards. What has your experience been with the Indian courts dealing with especially foreign arbitral awards? How have they been reacting, and are they interfering a lot, not enough? I mean, where are we on that scale?
That's a question for me, or Dheeraj?
So, Montek, in my experience, we are much better than.
Go for it.
I think that was for me, right, Montek?
Yes.
Yeah, please.
Sorry,
Yeah,
there's
yeah.
a complete freeze of mine.
In my experience, no worries. Can you hear me clearly?
Yeah.
Okay, great. So I was saying that in my experience, I've seen a very good assessment in terms.
Mm. I think we lost it.
Can you hear me?
Yes, now we can.
Right, great. So I was mentioning that I have, in my experience in the past few years, Indian courts have taken a very good approach of not interfering with arbitral awards, especially those which have been detailed and passed through international arbitrations. There have been instances, but again, our the script insofar as the interference is concerned is very limited now. So therefore, I think execution is happening, enforcements are happening, and courts are, at least in major cities like Delhi and Bombay and the Supreme Court, we've seen that the level of interference by court is kind of going down, and the courts are taking a view that we should not be interfering with arbitral awards. So it's becoming better now, in my view.
Okay, well, that's useful. And Vic, just on you, have you how has your experience been? And especially, I suspect when you're also engaged by foreign companies who might have an award to enforce against Indian parties in India, what's been your experience?
I think it's overall been positive. The Indian courts, be it the Supreme Court or the High Courts, have taken an overall positive view. The only sort of frustration that sometimes does come in is about the speed. The courts reach the right decision, but sometimes they take a little too long and are, a little more accommodative of an Indian party, or a respondent party that is unnecessarily kicking the sort of ball down the road just to sort of manage things in the background. And I think that is one frustration which, if addressed, I think then it overall it's going to be a very positive thing. But I think what the courts have done in terms of decision making has been phenomenal, and I think no one can say that there isn't a pro arbitration sense and trend in India now.
Yeah. Okay. Well, that's useful. I'm sure parties will find that very very encouraging. Ankit, I'm going to come to you now. You've been listening in on very patiently on the lawyers and counsel's perspective on the disputes and what's going wrong. You are in the middle of in perhaps many contentious industries. You are you're large. You have your hands in multiple sectors and geographies. What has your experience been, and what are you seeing as an organization, in terms of the disputes or the concern that you have in managing both your domestic and your cross-border investments?
Thank you, Montek, and thank you for inviting us to be part of this esteemed panel. Um, Overall sentiments of investors for India has definitely grown up during COVID situation. Now, India is being seen as a favorable destination by many players across the globe. And what we need right now is enabling policies. While no dearth of policies, but enabling policies are something which India definitely needs to probably figure it out with in consultation with the players of the market. Um, Policies play a major role both in terms of dispute settlement and giving or arising a dispute itself. Um, Dheeraj mentioned a particular point stating that the disputes arise when the investments don't return I'll say the ROR or what we call it, that is not coming through. So that is something which people have to understand the risk of the business. But if it is a calculated risk of a business, it is well understood. But if it is a policy lurch of in a business, then probably it becomes a bit difficult to understand. What we have seen in past years is at times there is a policy paralysis and at times there is a policy instability. Both of them are not good for the economy. While at the same time we need to move forward, the past experiences have to be considered while designing a policy. At the same time, when a company is getting stuck for policy decisions, the policy should be amended. Now, when we compare ourselves with international companies, we also need to compare ourselves with international policies, which enable investments in a particular location or a geographical location. When we do a comparison, it has to be an apple and apple comparison. It can't be a different set of variables because the variables here are too big. A natural resources company in a Commonwealth country similar in nature, like Australia or any other similar nation, will have a very different set of avenues, very different set of laws governing natural resources. At the same time, in India, the laws have to be evolved from a public sector driven company to a private sector driven company. Now, this is same thing across geographies. This is not only for natural resources, this is also for telecom sector, this is also for power sector. A lot of laws which have evolved over time were practically designed to govern public sector units. At the same time, the control governance had remained with the central government, and which has kind of, it was a good position at that point of time. Probably we need to change it right now. The concept of good governance needs to get start settling in, and it has to be self-governed. Government can't is not in a business to keep monitoring the situation. This is exactly what is leading to a lot of dispute. The moment there is a government monitoring, a dispute arises, be it a third party, be it a thing. Now, there are technology which are coming in. I'm sure, but eventually we'll all end up there. But it has to be self-reporting and it has to be audited. So I'm saying self-reporting with auditing. So if we do on that open air basis, in a practical business scenario, probably that will give a lot of rise to the investor confidence within India. Now, the second turf is on the judiciary side. Now, judiciary is overburdened with technological challenges in the COVID situation. The rate of disposal of cases which have been long pending is still, I'll say halfway through. At the same time, a lot of cases which when it comes to media personalities, when it comes to high profile cases which are there in the media, are coming through on a day basis. A lot of regular cases which should have been important from an Indian economic perspective have kind of gone on a back seat. Well, each one has its own way to look at things. We would like the court to see to it that each one gets a fair chance of representation before a court. At the same time, during the COVID, what has happened is that technology has enabled the judicial system, but we are still bound by certain, I'll say, drawbacks of technology, which probably has to be addressed in due course of time. Probably we need a good judicial reform in that area, right from a district court to a Supreme Court, so as to enable everything. Unnecessary filing, unnecessary interferences of the court in litigation should be avoided. We need to move forward while at the same time rights have to be preserved. But it doesn't mean that judicial systems overlay the existing rights and create roadblocks for development. So that and the only way which I see this roadblocks come or going away is by efficient, I'll say, interaction between the public sector, the private sector, and the government mechanism. That has to be increased to a extremely insufficient level. Litigation what are existing right now is majorly because of indifference, interpretation issue, multiple legislation talking on the same subject. Government is doing a wonderful job, like say unifying labor codes. One of the major areas of dispute within all, most of the industries are suffering from this labor thing. Well, each faction has a way of looking at things. Of course, each act requires modification, but at least a good thought process. Similarly, most of the interpretation issues in terms of day-to-day, like simple example, insolvency and bankruptcy code. Each NCLT is coming up with a different version or different interpretation of the same statute which is existing in the nation. The so many interpretation lead ultimately it leads to who is what and what rights can be enforced upon. Similarly, NGT is coming up with multiple interpretation of the Air Act, Water Act, and similar alikes of environmental legislation. Maybe a consolidated approach would have been efficient measure to see look at both what we are looking at from a stability perspective, and also we see to it that how best we can evaluate this what we call the judicial overreach of the situation. That's the pretty much thing. So I see from a corporate perspective a lot of ball rollbacks to the government to give us a policy which is business enabler, employee friendly. Each one has to be taken care of, environmentally active. When I say environmentally active, it's basically ESG enabled legislation. Somebody was talking to me about financing. What I'm seeing is that financing and carbon footprint should be interrelated to each other. The lesser carbon footprint you create, the better financing option you should give. Some of those benchmarks have to be established so that people start working towards a better ESG regime. Eventually, when India is a country of teeming billions, and we have to come up with a framework which is self-reliant, resilient for all of these changes altogether.
Yeah. And in fact, many there are institutions and now governments and commissions around the world which are trying to link your borrowing terms to your
Correct. Yes, absolutely. So that is what raising capital in India is the biggest difficulty right now. Okay? The cost of capital raised in India is around 8 to 12% on an average, given the nature of raising the capital.
Yeah.
But this is not the place across globally. There are specific banks which lend capital You need infrastructure to be developed. You need infrastructure to be developed to get economic benefit out of agriculture, for medical, anything requires infrastructure. And government is in no business to do a business out here. So the best way to do it is a private investment in these areas. But at the same time, when we do a private investment, you need a capital inflow. You need a regime set thing. But the problem, what happens here is that people invest or start investing, and then suddenly feel that the regime is not good enough for them because of ABCD region, whatever. But these risk factors have to be enabled, and somewhere it has to be circulated so that these risks are also mitigated at some point or other.
Yeah. No, very valid. Thank you, Ankit, for that. Just as a follow up, now you mentioned and you hinted at COVID as well. So I have two-part question for you on COVID. First, has it changed your willingness as a firm to bring forward new disputes, or are you trying to avoid spending money on disputes at this stage? And the second answer, which is linked to that question, is: are you now seeing a shift, perhaps from companies like yourselves, to see if you can mediate and settle the matters rather than get engaged in long-standing, expensive disputes? So, what has been your experience, in the background of COVID with
My
your investments and
personal experience is no company has an appetite for litigation. Okay, that's my
yeah,
personal experience. The problem in this thing is that the promoters probably have a different aspect of litigation.
yeah,
Lawyers, you being on the other side of the table, will always have a view supporting litigation. But as corporate counsels, we will try to see if there are no litigations at all, because there is no requirement of a litigation. If there's a point of dispute, let us sit down on a table and settle this down once and for all, and for everyone. Not only same disputes keep arising in a similar nature for across all geographies and across all industries, which is something which can be definitely be avoided by a better forum. For
yeah,
example, India, like for example, when we're talking about a cross-border thing, India is not a signatory currently to the ICSID regime, which is something which probably India as a nation may have thought about or may have pushed for it. So probably something, if not exit, something else, something on a WTO side could have been looked at to prevent something what has happened in Vodafone case.
yes,
Okay, so if those things are sorted out, probably better companies and much more companies will invest in India. I'll talk from natural resources sector. We have big companies, Valley, BHP, Rio Tinto, who were supposed to invest in India, have never come down to India. And there's enough room or enough game for them.
yeah,
But unfortunately, I think because of regime, because of legislative, because of past experiences, they choose not to come. The problem is it's not about them, it's about us as Indian.
yeah,
India, it has to grow, it has to rely upon natural resources, it has to rely upon infrastructure. And I firmly believe in that thing, because each one of us today or tomorrow has to rely upon the set of infrastructure to grow upon. Now, when these things are happening, when we talk about it from a COVID situation perspective, a lot of changes have happened. Yes, the budgets have been streamlined. Any cost allocation, any unforeseen cost allocation is kind of waived off. Litigation costs have to be drastically be reduced. So we're looking at a lesser number of disputes. We're just looking at I'll say, a streamlined lawyers or services of lawyers to be more streamlined, more effective dates and more effective hearings rather than just mere adjournment or evidence, and try to put everything in a shorter time frame. So that is something which as we as corporates are very willing to look forward to. I'm sure every each other corporate will share the similar view. But the cost of litigation is not only in terms of legal expenses, but also in terms of reputation and other risk area, which are kind of unforeseen and undocumented in terms of balance sheet numbers. Those things have to be definitely be taken care of. So post-COVID situation, yes, we are all streamlining our efforts to ensure that zero litigation moving forward, and also ensuring that whatever is existing, we resolve it at the earliest.
no, perfect. Thank you for that. Now, Sindhu, I know you've been sitting quietly and listening very patiently to all of us. I do want to come to you now, and clearly, one topic which has been spoken about is financing in different contexts, right? and I know we're going to talk about that a little later, but from your experience as someone who supports the financing in especially in disputes context, what are you seeing in terms of what kind of disputes are you seeing come through the door for funding, especially those that have an Indian angle?
Sure. I mean, globally, there have obviously been some COVID-specific disputes that are arising. Whether it's business interruption claims in the insurance context that Vivek mentioned earlier, or claims structured in various ways against the government response to the COVID crisis. And then there's just sort of an overall broad variety of business disputes, whether it's on the IP patent infringement side, or shareholder disputes, or antitrust matters and so on, things that were happening before COVID, things that will continue to sort of happen after COVID. In terms of India, we've seen a fairly broad variety of referrals. I think a lot of them, what's interesting is a lot of them are the type of disputes that we're discussing today. So cross-border disputes, foreign litigations and arbitrations rising out of overseas business activities of Indian companies. And I suspect the reason for that is they're quite expensive to run, as everyone else in the panel has been saying. In terms of sector, I agree with what Dheeraj and Vivek both said up front. There's no clear pattern. We've seen claims coming from the mining sector, infrastructure sector. We would continue to expect to see more of these. We would expect to see a few more supply chain disputes. Things may be coming out of pharma manufacturing, where again India is quite big and the contracts tend to be cross-border in nature. And then perhaps the sort of one interesting thing, and I know we're going to discuss this separately, is claims with an insolvency angle. Now, not necessarily classic recovery type actions, where companies are in insolvencies and the IPs are going after promoters, etc., to sort of increase the assets. We haven't yet seen things like that coming out of an IBC context. But what we are seeing is sort of cash-strapped companies working with their creditors and finding ways to kind of monetize, pre-insolvency, pre-COVID claims that are on their books that they just don't have the cash to bring. We're seeing referrals in that space.
Okay, thank you. I think that was very useful. At least I took a lot away from that in terms of the general landscape of the disputes, sort of the disputes involving India and Indian-related parties. Now, I want to just take a segue from what you just said, Sindhu, to the next theme we have for today's discussion is, financing. And you mentioned referrals in relation to claims where you don't have perhaps the capital to bring those claims forward, especially in the context of COVID and how that's caused a disruption in the cash flow activities of many corporates, especially the small and medium-sized enterprises, but also more broadly, right? Ankit mentioned certain forms of financing and linking some of those financing to even specific requirements, whether it's your carbon footprint. He also mentioned the cost of capital being high for his for general activities. He mentioned the range of 8 to 12%. But of course, those kind of financing is available for these larger corporates. It may not be available even for the smaller ones, actually. So how in sort of in the context of the sort of expensiveness, I guess, of capital of sponsoring even just operating activities, let alone disputes, how has third-party funding how can third-party funding be used by both small and medium enterprises, but also larger corporates who might have the capital otherwise to deploy it, but might want to save that capital for their business? So how have you seen third-party funders like yourself sort of play a role in that context?
Sure. I suppose for those who are not familiar with what third-party funding is, it's very simply financing provided to, bring and run your litigation, secured against your litigation as an asset. It's a bit like project finance. So if the case wins, the litigation funder takes a chunk of the winnings from the case, but if the case loses, the funder gets nothing. So it's non-recourse financing. very simply, right? Now, yes, of course, I think sort of third-party funding can be a necessity if a company simply doesn't have the cash to bring around a case for its duration. But I think TPF is useful for well-funded companies, and there are larger corporates who are starting to take advantage of it just as another source of financing. One is, I think, risk mitigation. I mean, TPF is non-recourse, so all of the financial risk associated with the litigation is no longer with you, but it's with the funder. I think that by itself is a reason every company, well funded or not, should at least consider litigation finance. Because I mean, we all know litigation is inherently unpredictable. However good your claim is, there's always a risk of things going wrong, whether it's with your witnesses or whether it's with an arbitrator taking an unexpected view on a legal point. So many things can go wrong. And of course, right, when you self-fund a case, you keep all of the returns. You don't have to part with some percentage of the winnings to a third-party funder. But on the converse side, you bear all the risk of things going wrong with your claim. Apart from risk mitigation, the other thing is sort of cash flow and the way litigation expenses are accounted for in a company's books. So when a company self-funds a litigation, I mean, the value of the claim itself obviously is something you cannot record on your books until the claim's actually realized. But leaving aside that, the problem is, while this case, for 5 years, for 10 years is going on, you've got to pay the costs of the litigation. You've got to pay the monthly invoices of your lawyers, expert fees, arbitrator fees, court fees, so on and so forth. And all of that does have to be recorded in real time as an operating cost in your P&L. So for the duration of a litigation, even if you've got an excellent claim and you think you're going to make recoveries at the end, it skews your P&L for the duration of a litigation, which again, depending on the costs of the litigation, depending on the size of the company, and depending on also how earnings, how important earnings are for a company, can be quite a substantial hit and a deterrent to bringing even good claims. Whereas when litigation funding is involved, the funder directly pays the cost of the litigation so the lawyer's fees and so on and so forth. So there's no hit at all to a company's P&L while the litigation is running, which can be a big advantage. And then I think there are some sort of softer advantages, if you will, to having a funder involved. I mean, most funders have significant litigation experience, so it can be sort of useful to have an extra pair of legal insight in your case, and their incentives are often very closely aligned with the claimant.
Is it just me or everybody's lost Sindhu? Okay, everybody's lost Sindhu. No, okay, so I mean, she was obviously explaining, general options available for funding third-party funding disputes. But just kind of building on what she said, I do want to come to Vivek, you first, and then Dheeraj next. Is in terms of the obviously, when we'll come back to Sindhu right after this question to elaborate further on what you were saying, but in short, of course, third-party funding allows you to fund, pursue your claim, and as Sindhu was explaining, the advantage for corporates that it's non-recourse, right? It's available, but you only have to pay it back if the claimant party is successful. Now, it sounds like a great concept, right? It seems like it's a fantastic way to reduce your cost and keep some of the upside. But the key question would be, is it legal? And is it legal in the jurisdictions where Indian companies often litigate or arbitrate their claims, whether it's Singapore, whether it's UK? So, Vivek, what's your view of the legality of third party funding in financing your claims? And the second part to that question is, how have you seen the use of third party funding generally increase, decrease, stay the same over the last few years, in relation to the matters that you are working on?
Thanks, Montek. I think when it comes to the legality, if you look at the international seats where you'll see a lot of Indian parties litigate and arbitrate, it's essentially UK. So you're looking at a London, a Singapore, a Hong Kong, and increasingly Dubai as well. And litigation funding is legal there. There is, you know, uh, legislative frameworks that are in place. There's even, there is jurisprudence, especially in England, where you have great cases like Davy versus Money, and there these sort of traditional arc and cap has been eroded now. So there is definitely legislative frameworks that are there. It is legal. When it comes to India, I think the judicial indication is there, but the legislative framework isn't there. And, considering that the maintenance and championship still remains on the books, I think there is a need for, I think, a clear legislation to sort of get things moving on that front, though I think the judicial indication is fairly clear. In terms of the disputes that I am seeing, I think that the overall trend has been that my big corporate clients still tend to pay their own bills. They want to pay their own bills. They're not very keen to use funding. Recently, they've started inquiring about it, and the reason usually is what Sindhu mentioned, is how you record it on the books. Some of the big disputes tend to run over a period of time, and you need to sort of record it into the books. And that's when the business and the finance team starts asking, can we do something with it? I don't want this to have these costs on my balance sheet. What do I do with it? It's not a question of can be afforded, but every finance team likes to sort of have a nice clean balance sheet, and you don't want to show outgoings to lawyers and experts every month, and usually they tend to be quite big. So that is when it comes to big corporates. Obviously, when it comes to the medium players or players who need the money, where its cash flow is a concern, it boils down to equality of arms, the ability to sort of access. I think their litigation funding is playing a very important role, and there is definitely an increase, and I think a lot of claimants are becoming more confident about their claims when they can sort of fund it, because I think earlier the claimants would realize that they can neither afford lawyers, they cannot afford experts, they cannot afford tribunal fees, they cannot you know dig into their financial resources to sustain a dispute over 3 years or longer to get an award which might be favorable, but it's about sustaining till that time. So I think there is definitely that increase.
Thank you, thank you. That's very important, and I think I know, just as you mentioned, also even if the question becomes perhaps a more difficult one when you are going against a respondent which is very well funded and you are not, right? And not only you might be able to afford representation, but it may not be the right level of expertise you require in the claim, which are often brought forward. So of course, it does go back to balancing the scale to a degree for the less fund or for especially smaller firms, like you said, which perhaps might not even have access to capital, let alone which want to just sort of mitigate the risk like larger corporates. But
Yeah.
Dheeraj,
And sir, and I don't know if I got cut off. Sorry, in when I was saying it last time, but uh, sort of very related to what you're saying is it almost has a deterrent effect as well on defendants when they see that there's a claimant who's got a funder with deep pockets who can see out any sort of dilatory tactics that they may be tempted to indulge in. It can sort of deter such behavior and actually bring them to the settlement table a little bit earlier than a self-funded claimant might be able to do.
yeah,
That was sort of the last thing I wanted to say before I got cut off.
no, that thank you. No, absolutely. Dheeraj, just coming back to you on what Vivek was saying. Um, do you see a concern in the use of third party funding in India? And what is your view of the current state of play for Indian companies trying to access such funding for their disputes?
So, Montek, I personally speaking, I haven't seen a lot of movement on the Indian clients side who are looking for funding insofar as litigation is concerned. Now, primarily, there could be two reasons for that. One is there are not many third-party funders, so to say, in India who are operating. There have been few of these companies which have come and made presentations, but I'm not too sure how many of them have really been able to convince the clients as to how they can actually fund the entire litigation. The second part of it is the absence of a very clear regulatory framework for it, because as you mentioned earlier, as Vivek was also saying, that while third party funding is not really recognized as a concept, we've had certain judgments of even the Supreme Court. For example, I think the Bar Council Balaji matter, where there are observations which kind of say that there is no objection for third party funding as long as it's not the lawyer who's funding the entire litigation. So which means if it's a company which is primarily doing third party funding, like what Sindhu, the company that Sindhu probably works for, maybe something like that is permissible in law. But having said that, and there's been a consistent decisions on that path. But you also have to consider that there are amendments which have been made in the CPC, Civil Procedure Code, by certain states such as Madhya Pradesh, Andhra Pradesh, and I think Gujarat also, where they have specifically said that the plaintiff will not be entitled to costs, etc., if the funding is done by a third party. Now, there it's about securing the entire costs of the litigation. But again, those are CPC, therefore, probably will apply only to litigations in court and not technically an arbitration, which probably is either an international commercial arbitration, which is happening outside India, or even somebody can argue that that CPC primarily, because also it's state amendment, will not apply to Indian states to arbitration proceedings. So I think one is lack of knowledge, a lack of awareness about this entire concept, and two, probably we haven't seen that kind of movement in India so far. So once clients get to know about it, I'm sure many people will want to try it as long as they think it's a good viable option and not hit by any regulatory issues.
Yeah, I mean, before I go into certain case considerations, and I definitely want to get Ankit's view because especially he mentioned about the financing and the cost of financing even for general activities. But Dheeraj, as a follow up, I appreciate perhaps to some degree today's conversation and this perhaps the earlier ones which have been on this topic are more academic at this point because it's not really taken up in a way which has enough case studies to help sort of draw from. But as a counsel who's often involved in high value, expensive disputes, do you see a sort of a niche perhaps for a funder, a third party funder to take up in a market like India, which obviously is a contentious market. The volume and scale of disputes is quite large. But how do you, I guess it's in part you're looking at a crystal ball right now, but in your view, how do you think there's a scope for third party funding to really pick up, and would your clients you tend to work with be sort of open to using such financing to pursue their goals?
Oh, yes, absolutely. I think there is a very, very large scope, and I think Sindhu mentioned it, that not having funds to kind of dispute with a foreign party is also sometimes a deterrent. So you may have a company, and I think Ankit also mentioned that not companies don't have an appetite for litigating, right? They don't really want to litigate if required, and also the books. You're going to be wasting good money over bad money or something like that. So if companies do figure out that there is some kind of a way to get funded for a litigation, especially when it is against an international client who has much more deeper pockets to fight, and in that situation, and we see this very, very typically. It happens, for example, in international arbitrations when we are pitted against very large foreign law firms, like Vivek, an international lawyer. We know the kind of fee they charge, and how expensive they are. So the Indian clients always end up using either Indian lawyers who are very not expensive as we are, right? And then charge probably almost 75% less than what Vivek must be charging. So I think that kind of brings a perspective to the funding itself. So if tomorrow my client says that, listen, this actually litigation is getting funded, they may not come to me, then they'll go to Vivek because they know they can afford a fee then. So I think it will kind of it will pick up
Yeah.
when it comes to India.
No, thank you. I think
Usually, I always agree with Dheeraj, but I think I might be cheaper than he is.
I will stay quiet on that one. I think no, I think, but no, a very very valid point. I think, and like as Sindhu was also saying, and this is where Ankit, I do want to come to you right after this. Is there's obviously a market for like the David versus Goliath story where you don't have the fund for a smaller, medium-sized enterprise to bring up a large claim. They can't afford, I would say, both perhaps Dheeraj and Vivek. But there's a secondary question, and Ankit, I really want your view here. Even for firms like yours, large global businesses, um, how do you see the use of third-party financing? And do you think a firm like yours, a organization like yours, would avail and benefit from having access to such financing?
See, something which is definitely worth looking at to save what we call as a good capital. So why waste money when you can fund a thing? The only challenge this thing is the whole scheme of things how a third party is exposed. One is of them is definitely confidentiality of a matter. Second is definitely in terms of since most of the claims are with the government or against the government, and ultimately the risk are being borne by any of the conglomerate, and the third party funding is benefiting only if you have if you're claiming back from a government, which in seldom cases is not the case, but you're technically in most of the cases you're defending a claim from the government, which doesn't work in a versus a private party. So that is something where third party funding may not be a very. I say we'll have to explore it. It's a very thin line since it is still an evolving concept. But third party funding for government has to be strategized a bit differently than it is currently structured. Plus the enabling provisions, there has to be some statutory backing on it, because otherwise it will lead to one set of another dispute with the third party funder itself.
That's
So
very valid. Yeah, I think that's. But do you see? I mean, just on picking up on, like you mentioned, the cost of financing. Let's put ourselves in an ideal position. Let's say, and the points Vivek and Dheeraj mentioned. Forget the regulatory issues in terms of using or accessing financing. Let's say that gets ironed out in the coming years, or hopefully months, as Sindhu hopefully might be hoping. But in terms of let's say you're in a situation where it is available to you. It is it's legal. It's the framework is clear. You had mentioned your cost of financing for just general activities, and I suspect when you said 8 to 12%, that's your cost of debt essentially. Cost of equity is
yes,
even higher.
yes,
Um, that debt is securitized, or it has access to your assets if you were to fail to pay them back. So while the cost might be 8 to 12%, the real cost of failure to pay that is perhaps much higher.
yes,
In that context, now I'm not going to tell you that, and I'm sure Sindhu will agree here, third party financing is not cheap per se. It's not like it's going to be 8% or 12%. Usually it's north of 10, 20% in terms of the returns they seek. But it is non recourse. You don't have to pay them a single dime if you were to fail in your claims. So it's purely contingent on the outcome of the case. Now, in that context, now again, I know I put you in a very ideal position here in terms of everything working otherwise. Is that something which is sort of, it has incentives for you, or is that something that you feel could definitely play a role in some, if not all, of your disputes, where you're able to use that capital you otherwise have secured against your assets for your business activities, and then use financing type Innsworth provides for financing those claims, which the arbitration claims which are ongoing as well.
Montek, with so much of utopian scenario, yes, it is possible. It's always a case. TPF works on algorithm basically, so their factors of variables are pretty high. The way they evaluate a case is against set precedents, set ratios in previous judgments, similar awards. Similarly, we will also do the same thing for TPF thing. I'll say it is worth evaluating, but at the same time, I told you that having a utopian structure in that way, yes, it does help us, but it doesn't safeguard us from the risk of a recovery. So if there's a recovery in schedule and there's a litigation against a recovery, TPF may help us in funding that thing. But recovery, there's a difference between recovery and defending a demand. So that is where the major thing will lie. And if they would ideally, if government was on their side or they were to fund a government suit, then that is a better market for them than a third party, than a corporate itself. Because right
Yeah,
now,
yeah. No, I think that of course the it's perhaps more useful for private clients or private corporates who have claims against the
yes,
government, which are rather than rather than a claim
rather than the claims against a demand, which is
demand.
again, yeah. So that is where most of the demand, like say, the biggest of the cases are on terms of demands made by the government,
That's right.
um, and
That's right.
not on the private side. So that is the bigger amount I'm talking about, be it
Understood.
in resources sector, be it in telecom sector and the likes, where the
Understood.
third party funding may not be very helpful if because one, the things are not quantified at all. The and second, the confidentiality of it may be a big aspect to it, so which probably somebody has to look into it.
Yeah. When you say
And
quantified at all, you mean where the claims are not quantified or
yes,
not yet?
the claims are not crystallized, I'll say.
Got it.
There's always a cross questioning going on the claim side.
Yeah. Yeah.
Sindhu, your views on this thing? Because I'm sure you would have a different view on this aspect.
Um, I mean, in terms of sort of non-monetary damages, which I think is sort of one part of what you said, that is something that we're actually quite used to dealing with and should not be an absolute deterrent to funding. Now, oftentimes, you when you defend a matter, the outcome is you've actually earned yourself a valuable right. Whether it's some sort of an IP right or whether it's some sort of a contractual right. If we can find, or you might have won yourself an asset, so long as we can find a way to sort of evaluate the monetary value of that asset and find a way to take our returns out of it, we wouldn't be close to the idea of funding on that basis. We wouldn't say, oh, it has to be monetary damages. So
Okay.
that's confidentiality is interesting, and I think I know I dropped off when Vivek was talking about it. In some ways, it depends on the jurisdiction where the matter is, because it's really the laws of each place where a litigation or arbitration is being fought that have a greater role to play in how much confidentiality or privilege really is lost when you share information with a funder. And usually, funders are sort of well cognizant of the rules in different jurisdictions and are careful about how we ask for information sharing with the claimant to make sure that you don't lose privilege over that information in the course of that litigation. That's something we're highly cognizant of. So, I mean, simple example is, US is far more restrictive. We're far more restricted in how much information we can ask for and the form in which we share information with the lawyers in the US than say in the UK. And that's just because of the rules of privilege in that jurisdiction. So I think that's, again, there's no one size fits all. And in some senses in India, I suppose what's unhelpful in all of these, with all of these sort of slightly knotty issues, is there is no clear regime. We sort of have to work out for ourselves what the rules are, and it's untested.
Got it.
No, thank you. I know we are almost at halfway mark, more than a halfway mark. So I just have one question. So we to Sindhu, you and of course, and others will chime in. So we've discussed, of course, the legality, the use, the potential way it can be deployed. Now, I guess the key question is, it's all sounds great, but obviously you don't fund everything that comes to you. So how do you evaluate a case for funding? How do you think about whether a case would something you be comfortable with funding or not? What are the key case considerations that us as practitioners, Vivek and Dheeraj, when they are helping their client, and of course Ankit, when he's thinking of funding his claim, should keep in mind before bringing it to someone like you?
Sure. I mean, there's really no set formula. So many cases that we get for funding are novel law cases. So we're used to dealing with situations where there's no precedent, it's never been done before. But fundamentally, I think, there's lots of aspects of a case a funder will look at. But fundamentally, it's about merits. I think it's about legal merits and it's about economic merits. Is the case likely to succeed on the law and on evidence? And is it going to leave me as the funder with a adequate return and the claimant with a fair share of the proceeds as well? So what this means practically is when you're doing a due diligence exercise, you're going to look at the legal and factual arguments of each side. You're going to look at the evidence. You're going to very carefully look at the likely value of the case, the likely damages or settlement, the legal theory that supports this, as well as the factual and expert evidence that supports it. You're going to look at the jurisdiction where the claim is proposed to be brought. You're going to look at the duration, the risks associated with that duration, as well as how long that matter is going to take before it's settled or reaches trial. You're going to look at the budget, particularly the budget versus how much the expected recoveries are. You're also going to look at other things. You will likely ask the lawyers to be fairly comprehensive in their budget. And then I think, again, some of the softer stuff, you're going to look at the defendant, you're going to look at their financial history and litigation history. Can they satisfy any settlement or judgment? How hard are they going to fight? How much of an adverse cost exposure does that give me? You're going to look at the claimant. Again, you're going to look at whether they're sort of, commercial and they're going to be commercial and pragmatic in their decision-making process, whether they're going to be motivated to fight the case and, dedicate sufficient resources to fight the case. And of course, you're going to look and pay very careful attention to who the counsel team are and, include and who the experts involved in the case are.
Thank you. So in short, a strong case for legally merit-wise and quantum-wise. No, that's very helpful. I think that's important to know that, because I think the other advantage of bringing someone up early, and again, perhaps if Dheeraj and Vivek have any inputs on this, please do chime in again, is it does force the client, the claimant, to evaluate the case quite early on. And it forces, and Ankit, goes to your point also on the, where claims are not quantified, for example, it forces the team to evaluate those claims and what they are. Are they strong in law? Are they strong in facts and evidence? And are they strong on experts in terms of quantum? Are they well quantified? Are they well supported? So that's something that it's forced almost, because you all will require a minimum level of due diligence in the claims you will fund, and these questions often come up in the process. So I know, Vivek, you just unmuted yourself, so you obviously have something to add. So please do.
No, I think the point Sindhu made is very pertinent. I think often what happens when you're filing a claim in arbitration, if it is self-funded, it often gets filed in a semi-formed manner where, you have a sort of lay of the land, but, you haven't sort of dotted everything. But when you have a funder involved, you need to completely map it out. And I think that's a very useful process. And that sometimes can be a great advantage, because it makes you think of a lot of issues which you haven't. And it sometimes it gives the lawyers an opportunity to sort of have some difficult conversations with the client early on, which, when there is that filing pressure, you sometimes cannot, and you just focus on getting that request in.
Yeah, Absolutely, absolutely. Okay, with that, I'm going to now hand it off to Sindhu to take the rest of the discussion forward. So, Sindhu, over to you.
Sure. I mean, the next topic of the panel is the role of quantum experts. I mean, in particularly in disputes abroad, I think quantum experts have a very, very important role to play. As funders, I mean, I know that we often see or commission expert reports upfront when a case is being brought to us for funding, particularly where we think quantum is going to be a contested issue. And as I was saying, sort of just before this, we do pay close attention to who the expert is when we're assessing a case. I suppose with that, let me ask Montek, who's the expert on the topic of experts. Montek, you've been dealing with in India-related disputes for quite a while. I suppose what have you seen in the market in terms of how quantum experts are being used? Have you seen an uptick in use? Did you find that it was not being routinely used earlier and it's changed? How has it changed over time?
Thank you. No, thank you. So I think as a preliminary remark, obviously when you talk about experts, particularly those for quantifying damages, are often considered for perhaps the more complex and complicated cases, and when the questions that need to be answered aren't necessarily straightforward, or there's some uncertainty in the outcome, or answering the question requires a more careful view and analysis of the wider evidence, which can span multiple disciplines and subjects. So some questions often come to us include questions on valuation of businesses and shares. It could be a loss of profits calculation for a contractual breach. It could be analyzing costs incurred in business activities or the effect of disruptions and delay on such cost, especially in the infrastructure sector. It could be value of patents and IP rights. So these are questions which, like I said, span multiple disciplines and are often complicated. And these are the questions that often come to us. So it's a subset of the disputes that are out there, right? Not every dispute is going to have always have such complicated questions, like a question which Ankit was mentioning earlier, which are perhaps of demand or simply reconciliation of invoices. Frankly, don't need people like us. But with that background, at least in terms of, you mentioned India, and like you said, in the global context, especially cross-border disputes, which involve the questions of the types I was just mentioning, use of experts is very common, right? It's actually, in fact, every case, at least I know of, which has such complicated questions, will have quantum experts involved. In fact, a recent study by LCIA stated that all of the 300 disputes, almost all of them had multiple experts involved. In India, and again, I think Dheeraj will have much better insight into this, but in India, the use of experts has been traditionally quite low, including for the questions I was just mentioning, which are difficult future forecasts of businesses' performance or loss of profits claims under a cancelled or terminated contract, or it could be exit disputes, which are becoming quite hot in India in relation to private equity. Um, it was nascent, perhaps, at least in my view, when I first moved back 5 years ago to India. It was perhaps a bit of lack of awareness about experts existing and people answering such questions routinely in the context of arbitration and litigation. It was perhaps to some degree the lack of acceptance from the tribunals and judiciary, because they were not accustomed to seeing expert evidence of the type I've been describing in the disputes. And perhaps it was a question of costs, because obviously we come with certain fees on the matter. That said, I definitely and luckily have seen an increase in use of experts in the last 5 years. I think directionally, people are becoming at least more aware of people like us and using people like us to help substantiate the claims. And that's principally driven by, I think, counsel wanting to understand claims and damages issues much more, with much more depth, and perhaps much earlier on in the process than perhaps what was the case 10, 15 years ago. And I think that, coupled with, especially again, the cross-border scenario, which is in the theme of today's topic, the increasing requirement for tribunals to have well substantiated and supported claims. And in fact, the Delhi High Court has actually even rejected or returned case awards where quantum was not properly quantified, or someone used a figure without much support. So it's gaining that acceptance and that requirement to have those substantiated claims, and especially where your claims are hundreds of crores, right? Gone are the days you could just sort of wing your answers and put a figure which you felt good about. You now are required to substantiate and justify your claims at a higher degree, or at a higher evidentiary value than has been the case, at least. So I think so. In short, yes, it's definitely increasing. In the use of experts is definitely increasing. There's an uptick in the use of experts, both domestic arbitration and dispute, but of course in cross-border ones. And frankly, just as a closing remark on this point is, um, what has happened actually, including in the context of COVID, for example, the uncertainty has increased of any calculation. So imagine forecasting a business performance in 2018 and 2019 versus forecasting a business performance today. It's even more difficult than what it was. And that is again further sort of necessitated, or maybe perhaps even promoted the use of people like us to help quantify losses in a inherently uncertain scenario, with multiple disruptions being caused in the wider markets, and again prompted the use of individuals in making sure the claims are properly assessed and properly analyzed. So I think those are my remarks on on how the experts, or how the use of experts has been changing in the local market.
No, that's extremely helpful. And Dheeraj, question for you, I suppose. I mean, does your experience corroborate everything Montek's been saying? Is this something? Have you been pushing the use of expert evidence as well, with your clients? And I suppose, what's the reception been?
So, what Montek said is so apt in terms of my experience, and I'll share that a little beyond that. I think about 15 years back, we had done a major arbitration, and this was two big companies fighting against each other, and they were both promoters fighting against each other, and we filed an arbitration. They had filed a claim against us, and we had, just to, as usually, you will file a counterclaim. And in the counterclaim, we were sitting in the office, and we were making the counterclaim. We said, okay, now finally we said damages. So how much should we put? And the counsel told me, how much do you want to put? I said, how much do you want? He said, let's put 50 crores. I said, let's put 100 crores. So we just put 100 crores there, just, without even thinking what we are asking, why we are asking. We just put it there. And when it went to the arbitration, one of the tribunal members happened to be Justice Sri Krishna. And he asked us, in the first few days of the hearing, he said, how have you arrived at this 100 crores? So he said, well, damages, and that's all. So like, but you must have some basis. And like, no, we don't have any basis. Like, okay, fine, we'll see it at the end of it. It's only much later, and as I'm saying, this was about 15, 16 years old story. It's only later on when I started getting involved into international arbitrations and stuff. In fact, my first experience with an expert was from FTI, and I think Montek knows who I'm referring to. I think it was in Singapore when Richard was then working with FTI, and I saw it was happening. And it, not only the fact that I saw an expert, I saw something called hot tubbing in arbitration. It was completely an eye opener. And since then, I have at least started, wherever we get into any kind of an arbitration situation, I have actually started involving experts from day one. And Montek is actually witness to that, that in many, many matters, right at the inception, we have started involving FTI wherever there is no conflict, to start assessing as to on what heads can we ask for. Sometimes as lawyers, we also don't know that we could probably claim a particular damage or a compensation under a particular head. It's as some, it may not strike me, but as an expert, he may be able to tell us that, listen, in your pleading you can probably even use this, at the beginning itself, and then kind of it also helps us to mold the claim in that fashion. So yes, the short answer is, we have started using experts a lot right from the beginning. In fact, on all matters that we are doing, especially on the arbitration side, we are actually using experts in all matters now. So it's progressing very, very rapidly now, the use of experts.
And Ankit, what's sort of your view on the use of experts? Would you is this something you've had experience with? Is this do you find it's a useful addition? Do you find it a costly exercise? I suppose what are your views on involving experts, and when do you like to get them involved when you're considering your disputes?
Sindhu, empanelment of experts, we do have our own panel of experts when it comes down to natural resource sector, whom we engage for in our discussions with, I'll say, on a larger forum. When it comes down to dispute, it is advisable to have an expert opinion and also help us in our thing. But again, as I told you, the government is reluctant at times. So until and unless there is a they don't accept it. Our appointment of howsoever independent expert is always a questionable thing in on terms of independence and what the expert is stating until and unless it is not certified by a government or something similar in nature, which is one of the reasons why in most of the government dispute, expert witnesses are generally appointed only by the government, and which leads to a bit of a confusing status as when you call it from a dispute between a government and a private party. In terms of dispute between private parties, of course, expert help is a lot required, specifically in environmental matters. I see a lot of assistance in environmental matter because most of the people are not aware about the environmental laws and the nature of damages issues in that case. So yes, it is very helpful. A general awareness is developing. Experts are pretty useful in terms of resolving and coming to a conclusion at a faster pace. Uh, the only hindrance which I see is the acceptability of the expert and their independence, which kind of is questioned not toward the starting of a dispute, but towards the end of the dispute, if it goes against the adjudicator. So that is the one which I see.
Okay, and okay, that's very helpful. I mean, Montek, sort of circling back to you, and this is really the last big question on this theme, which is you sort of mentioned how COVID has made you has made your life more difficult in some of the quantification exercises that you're undertaking, and you gave us the example of business forecast and how it's how it's virtually impossible to do so with any accuracy in this environment. What else has COVID kind of thrown up in your world and in the world of quantum?
The, it's the exam question in all the disputes over the last 8 months, and the question that comes out repeatedly in the claims we have been asked to assess. I think so. The opening remark I would make on this point is: look, the framework obviously has not changed. The framework you want to apply to quantify damages, the way you would go about, applying the approach to quantify losses does not change. In fact, if anything more, it's forced to go back to principles and go back to the framework to apply it consistently, even in situations of higher uncertainty like the one we are experiencing today. But of course, what has happened is that framework and the approach have become more sensitized to key inputs and decisions and require a more careful analysis. So, for example, some aspects which are perhaps more difficult or perhaps where experts should play more emphasis on could include first, like the appropriate date of valuation. So, as you know, losses are measured at a point in time. Now, that decision has become even more important today. Now, think about if I was asked to assess the performance of an airline industry as of 1st of January 2020, those forecasts would have been very different to those I would have made in March 2020, April 2020, or even today, right? So choosing the right date of assessment, because valuations, like I said, are assessed as at a date, which often means hindsight is not allowed, or usually experts are instructed not to take into account information after the valuation date, becomes critical. And with the speed with which new information is coming to light in the current situation, right, and how things have evolved as regards to capital markets, the underlying economies, the government actions, uh, the data of assessment become even more critical, right? Just look at our stock markets, how they have evolved over the last 8 months. Look at the news of vaccines coming out in the last 3 weeks, right? So decisions or calculations performed before such large events or after such large events could have a large impact on how you might go about assessing the losses. The second factor is the reliability and interpretation of valuation and damages data, which needs much more careful thought. So the example I was earlier discussing is forecast, right? Forecast is often for businesses, it's a measure of the price you expect for a product and the cost you might incur to make that product, for example. Now, price and cost data, often experts will rely on historical records, historical information. Now, use of history in a situation like COVID becomes less important because those metrics may not be as applicable today. Um, you know, Similarly, macroeconomic data, right? How if you are an oil and gas industry in the oil and gas sector or in the mining sector, commodity prices have been really volatile in the current scenario, right? For in some respect because of COVID, but of course, oil and gas has had its own sort of complications which has affected the how the prices evolved over the last 12 months. So the data which often we rely upon is definitely perhaps is more volatile and has lags, right? By the time we are doing an assessment and the data is from say 3 months ago, a lot has happened in a situation like COVID over that 3 months. So you have to again. So what I'm trying to say is you require perhaps a more careful analysis of the data you are going to be relying on for making your assumptions and a calculation of loss. The third you mentioned was you hinted at the risk factor, and it's, like you said, it's virtually impossible to come up with a forecast. I think as valuers and experts, you have to recognize that, right? You can't just shy away because it's difficult to do, but you have to analyze what the risks are which are attaching to your your matter, to your client's future performance, and deal with it and model it in the various options which are available to us to make sure that while it is difficult, there are ways to incorporate the risk in your calculations. And I think experts just need to be upfront about that and make a conscious effort in understanding those risks and how they might impact your calculation of damages. I think the fourth and perhaps the last important point here is, and I think this is really the exam question, is you should be able to isolate the impact of COVID from the breach. That is critical, and that exercise of isolation of causation becomes more difficult in a market scenario like today, right? So how much of the underperformance, how much of the poor performance of the claiming party is actually because of the breach versus just because of market conditions like COVID, right? And that exam question is very important. I'll give you a simple example. Let's say there was a supply contract gone wrong and the supplier failed to supply the raw material to you, right? In a traditional normal scenario, you would say, look, had you given me the raw material, I'll produce my product and sold it in the market, right? Usually that's the case. That's the claim you're making for damages. It's essentially one of loss of profits. You lost profits on being able to manufacture your product and sell it into the market. Now, take the same scenario in COVID. Let's say that the supplier was to supply raw material to you, and let's say that is established to be a breach. Now, had he supplied the raw material to you, would you have even been able to produce the goods because you were in a lockdown? Or could you have even sold those goods because there was no demand for the product suddenly for that you would have manufactured during COVID, right? These questions are not necessarily relevant or even that interesting in ordinary course of business in usual times, but quite critical because supply and value chains have been superbly disrupted by COVID, right? So I will give you an example of a nature of a dispute where you might have a breach, you may not have any losses, right? Because you couldn't
Because
have.
of COVID.
Yeah, and it's an interesting question. I was dealing with one in the hospitality industry where a hotel and certain restaurants were shut because of COVID, and the dispute was by the manager of the hotel that, oh, you only lost profits, you didn't sign this agreement, you didn't do that, and our rebuttal was, for what joy? Even if you had signed the management agreements, the hotel is running at 0% occupancy. So what have you really lost, right? Um, so these are questions which are quite interesting and quite difficult. I mean, of course, I'm giving you extreme examples. It becomes more difficult when it's more nuanced, like in the oil and gas industry, where some impact might be COVID, some might be because of market conditions. So again, isolating what the breach has meant to your operations becomes more difficult, and the causation, which is of course a very important factor to consider in establishing and proving damages, becomes much more difficult to establish in the current background. So I think those are 3 or 4 factors I think have become more difficult, which is good, and it's prompted more companies to use people like us because they require experts to think through these questions more carefully.
Always a silver lining. But that was extremely interesting, and just for me to hear academically as well. I think that's really it on experts. I don't know if we've managed to get Suharsh on the panel to go through the questions on insolvency. Montek, I don't know if you heard anything further on that, or if not, I think I will I can simply ask those 1 or 2 questions to Dheeraj perhaps, and just give us a sense of what's happening in the market.
So I do see him online.
Oh, you can?
I'm assuming he's an attendee, absolutely an attendee, and he's marked as a speaker. Maybe I can just prompt the INBA team. Can you? There's Suharsh is already online, but we don't seem to have him on this speaker panel. And even though he's marked as a speaker and under the attendees, can you help with that at all?
Yes, Montek.
Yeah.
Hi guys. We cannot invite the speaker at this time and add him. All the ones who are attendees have the permission only to attend the event. They cannot come here and speak. If the permission was required, should have told us slightly prior. We have to create a link and send it to that person. So it's slightly sensitive here. Yeah.
Just to be clear, he has the link. I think the link was sent by Babit.
That link is for the participation. The attendee link is different. The speaker link is different. The moment we make, we go to your session, India Codes and Cross-Border Dispute. The moment we see there, we'll see only 5 of you there, right? And the host and the other speaker who's from INBA, the member. We have to add that person in that main list. It's the back-end issues. We will create, but it will take 10 minutes. Unless it urgently required, I'll request my team to add him as a speaker for some time. Okay? So give me 10 minutes. Meanwhile, you can carry on with the conversation. I'll get him back to you after 10 minutes. We'll immediately send the link to Montek. You forward the link to him, then he can add the link and come. However, you cannot come through the phone. Thank you so much. Over to you guys. Yeah.
Montek, in 10 minutes, the session will get over.
Yeah.
I think you just have to apologize to your colleague.
Yeah. That's okay. I mean, I think in terms of the question itself, it was
10 minutes. Never mind. We'll extend your session by 15 minutes. No issues at all here. No issues at all. Please take your time. We don't want to end the conversation. It's a wonderful session going on. Just that connection issues will happen here. The software is such. They're trying with us. We're new to this. Yeah. So you can carry on. Meanwhile, let me get him connected here. No issues at all. But it'll take 10 minutes, I'm telling you right now. So we can extend your session by 15, 20, half an hour. At the most by half an hour. So please carry on.
I think why don't you try and parallel? But I think Dheeraj and Vivek have to live up to their expensive rates and work as well. So unfortunately, we've already kept them for 2 hours. But Sindhu, why don't you just continue? And Suharsh, I see you online. It's really a shame that the link was a wrong one that was sent to you. It would have been fantastic to have you. But
I have a suggestion. Why don't you just call Suharsh and put him on speaker, so we can all just hear? You can just put him on speaker, and we can do that, right? We can just ask Sindhu can just ask the question, and he can hear it. Anyway, he's listening to us as a participant, and he can just speak through your phone on the loudspeaker.
That might be a good way to combine 2 different technologies. Yes. Sindhu, can you try?
I'll call Suharsh.
Because I think I'm also learning all these parallel.
Link sent was not wrong. Okay, let me come back to you again. Link sent was not wrong. If he was a speaker, he'll show as a speaker. If he was just there to, attend the event, he'll attend the event. That's it.
That's
and
what I'm saying.
Babita's connecting with him. Yeah, Babita's connecting with him anyways from the office.
I can see him actually marked as a speaker also on the panel. I can see that, but I can't. Obviously, we can't see him.
Okay. Yes, Babita is in a different office. She's already connected with him. She's updated me that yes, the link was sent to him in the morning. He has to connect through that link. He's still logging in with the old link. That's the issue that's coming now. He's still logging in with the old link. He has to connect through the new link sent to him today morning.
Okay, my understanding. Okay, Sindhu, have you tried on the phone? Yeah, might be at least in the meantime.
Yes, yes. I'll just put my.
I think this is a good example that everywhere there's been mainstreaming of technology, be it disputes or outside disputes.
Exactly. I mean, yeah.
Vivek, have you started with physical courts in
So we've
London?
got Suharsh on the phone. Say something,
Hi,
Suharsh.
hi
Let's see
everyone.
if people can hear you.
Am I audible?
Excellent. Yes, there are thumbs up,
Okay, thank you.
thumbs ups all around.
I've had the benefit of hearing you guys for the past 45 minutes, so it's been a riveting conversation. Thank you for inviting me.
No, thank you for being here. And really, I mean, we had a sort of good discussion in the first hour as well, just about market trends and everything that we're seeing in the disputes market in India. And I think it's really part of that conversation that we wanted to talk to you as well on sort of insolvency and its interplay with the disputes market. I mean, as we all know, COVID's caused all sorts of unprecedented economic challenges for businesses. And interestingly, I mean, almost in parallel and almost sort of at the same time, India has had a lot of movement with its insolvency regime in recent years. So I suppose, I mean, really, it's for the main question for you is: can you give us a sense of what you're seeing with respect to first, I guess, just insolvencies in India? Have you seen an increase post-COVID in terms of real insolvency? I know there's been a moratorium and so on. But what are you seeing, and I think what are you sort of expecting to see in the next year or so with businesses in India?
So, I think on the how we see insolvencies panning out, I'll take that question first. So, I mean, COVID obviously has seen because of COVID, there's been a serious contraction of the economy. The experts were here, so I won't dwell too much onto that. But some figures that we have from the RBI in the latest asset quality report of the RBI. RBI believes that the asset quality and the non-performing asset ratio of banks is going to deteriorate to about 15%. And in extreme circumstances, it will go up to 18 to 20% as well. At the same time, the tier 1 capital of the banks will also face serious erosion. So we are seeing stress not only in the real economy amongst the borrowers, but we're also seeing stress amongst the banks. I mean, of course, the fact that the RBI has waived accrual of interest for a certain timeline, which of course keeps getting extended by the Supreme Court, and the fact that NPA recognition has also been stayed by the RBI, that lead to a provisional or a temporary relief to banks because they don't need to keep providing for loans which are not declared as non-performing assets. But I think as a temporary reprieve, I mean, sooner or later those loans will come back and bite us, and that needs to be recognized. The second point to make is the 15 or 20% NPAs obviously has a direct impact on the real economy. Because of COVID, the operation of the bankruptcy law had been suspended from end of March. It could go up to potentially 1 year. So currently it's going to terminate in December. But my hunch is that we will see IBC being terminated or put in abeyance till about March of next year. So, which means that there'll be a huge influx of cases after March. And moreover, the cases which are already filed before March or where defaults had taken place before March, those cases can still be filed. So to summarize, I think the stress is real. There is going to be a big onslaught of cases sooner than later. And this will cause distress not only in the real economy, but also in the banking sector. Now, how that interplays with litigation and litigation funding, I can offer my 2 bits. I confess I'm not an expert in litigation funding, but the design of the bankruptcy code is such that once the company goes into bankruptcy and an insolvency professional takes over, then under the provisions of the code, he's duty bound to evaluate certain transactions of the company in the period leading up to bankruptcy. These transactions are basically in the nature of undervalued, fraudulent, preferential transactions, or even transactions where the directors have been negligent in their duties. And the concept of wrongful trading, which Sindhu, you'll be very well aware of under English law. So those are transactions and those are events which the resolution professional has an obligation to investigate. And more often than not, we find that given the very closely held structure of companies in India, where promoters wield a very high degree of control and power, we find that there is a large amount of self-dealing before the company goes into bankruptcy. There are related party contracts, there are instances of siphoning off, and so on. So there is a huge amount of litigation which is coming in from that front. So litigation is certainly there. The issue is funding. And the reason I say that is because every insolvency case has a finite timeline. It comes to a closure when either the new bidder takes over or the company goes into liquidation. Let's look at both scenarios. So once the new bidder takes over, then the resolution professional is functus of issue. The resolution professional no longer has any role to play in the IBC process. And therefore, he is not able to dip into the funds of the company to fund the litigation. And the litigation then basically is headless, and the new bidder who takes on does not really have a real incentive to pursue the matter too much, and on the other side of the matter, you have got the ex-promoters of the company who have already lost control of the company, and now people are looking to go after their personal assets. So they are obviously very well funded. They go for the best senior counsel and can defend the matter. And on the other side, you find there's a real imbalance because the company in the hands of new management is not really incentivized to pursue those matters. I think the missing link over here is that for whose benefit are those matters being pursued? And inevitably, we find that those matters are being pursued by the resolution professional or, in case a new bidder comes in. Not for the company's benefit, but for the benefit of the lenders of the company. Right? And unfortunately, the lenders have not really got on or have not really understood the inherent value in these transactions and how much value can be unearthed if these transactions are taken to their logical conclusion. So I think there is a huge scope of educating, of reaching out to banks and explaining to them that the real deal may be resolution of the company which is in bankruptcy. But a huge amount of value also resides in these transactions, which, if avoided, can lead to recoveries to banks. To give an example, Sindhu, you and I have discussed this, and this is in the press, so I can mention it. So in DHFL, where my firm AZB is representing the administrator, we have filed avoidance applications already to the extent of 20 to 20,000, 25,000 crore. So even if you do some sort of an analysis on the probability of recovery and the timeline for recovery, there's a huge amount of value. But any new bidder who comes in may not really have that incentivization. So I think there is a huge missing market over there, and very happy to hear views of other people, but that's something which I believe must be pursued.
No, that's fascinating. And if sort of try to summarize it, I think the couple of things really stand out to me, which is that because of this promoter-driven culture, there is likely to be claims of the type that come directly out of insolvency, whether it's wrongful trading or transactions at an undervalue that have taken place, too close to the insolvency, just because of the promoter-driven nature of the way business is done here. Those sorts of claims are likely to be common. And the other sort of interesting point that I've picked up on is a lot of these claims are just not monetized for. In spite of the IP being duty bound to either maximize the value of the estate or just investigate things properly, and that's because if it's restructured successfully, there's new management isn't incentivized to bring these claims, and there's also an imbalance in terms of a lot of these claims, I suppose, are against the promoters, and there's a David Goliath situation here in terms of the resources of the IP and the resources of the promoters. Very interesting, and for whatever reason, creditors are not driving the IP forward. So it's quite interesting. I mean, and do you see this? I mean, do you see the missing link really just being funding? Do you see it being? Do you also sort of see it as IPs in some ways? I think feeling a bit more duty bound to monetize these claims.
So that's a very good point, Sindhu. I think it's also an attitude problem with the judges as well, because the NCLT is. Sorry, am I audible?
Yeah.
I think in the video there's a bit of a lag, so I can still see you speaking in the video. But can I go ahead?
Yes, I think people can hear.
Sure. So the NCLT, the Bankruptcy Court, is already flooded with a lot of cases, and there's a lot of litigation going on when the resolution plan is put for approval of the NCLT. So even the judges, their focus is on the resolution plan itself, and for them the whole avoidance action is a bit of a sideshow. And the reason that's again so is because you don't have, I think you've got very distinguished panelists over here. I think they all appreciate that in India, getting a hearing means getting expensive lawyers, senior counsels banging on the table and trying to get the attention of judges, and to get matters listed and heard. But because there is very little attention given to this, you don't even have that sort of impetus from senior counsel trying to get these matters heard. So they are filed, and then everybody just takes a step back. So I think that's an attitude problem as well. As far as the insolvency professional is concerned, in my experience, I have found that they do it as more of a tick the box exercise. They feel that it needs to be done because it's their statutory obligation, and more often than not, I have seen that they do a rather shoddy job. They just file it because they know they'll never get heard, and if it gets heard, then the opposing counsel will keep getting it adjourned for years to come. So I think insolvency professionals need to also realize the value in it. And my suggestion would be that there should be some element of incentivization for insolvency professionals as well. They should get a slice of the recovery. And I don't think that's unprecedented, because if the company goes into liquidation, then under liquidation regulations, insolvency professionals can get a slice of the recovery when they liquidate the assets. So it's not a concept which is unheard of under Indian bankruptcy law. My suggestion would be we expand the concept, and even for recovery under these avoidance transactions, a slice of the recovery should go to the insolvency professional. I think that's when incentives will be aligned, and they will get the best possible experts to do the investigation, get proper forensic experts and auditors and accountants to do the investigation, do the valuation, and be able to convince other stakeholders to hire the best possible counsel and lawyers to pursue the case. So, I keep going back to DHFL because that's one case where it is an exception. We've got senior counsel looking at the drafts of the applications, senior counsel arguing the avoidance applications, and I think the impetus has come because the resolution professional in this case has been appointed by the RBI, given the systemically important nature of this bankruptcy. And given the financial stability element in this bankruptcy, there's a huge amount of impetus. But that's a real exception. In the other cases, we have not seen that sort of traction.
Okay, very very interesting, and I think one for both lawyers and funders, I suppose to develop. Question for Vivek, really, and sort of coming back to the cross-border nature of all this is one thing we've you often see with foreign insolvencies is holdout creditor action. Is that something you've seen quite a bit of, or any of at all in the context of insolvencies under the IBC, and perhaps English creditors or acting as holdout creditors in disputes outside of India? Is that something you've been observing?
So you have to repeat the question. There was a slight blank.
Before Vivek starts, I need to jump off from this panel. It's 1 o'clock, and I need to be for a mentioning at 1:15. So thank you so much for having me. And Vivek, I'm sorry I won't be able to hear to your last answer, but I'll catch up with you separately. And thank you all. Thanks, Sindhu, Ankit, Montek. Nice meeting all of you here.
See you.
Bye bye.
Bye.
See
Thank you.
you.
Sorry, Vivek, which part? Should I repeat that generally or?
Yes, I just sort of blanked out for a second. So please do repeat the question.
No, not at all. I was just asking this, holdout actions actions by holdout creditors and are notoriously common, particularly in the UK when there are foreign insolvencies involved. I was wondering, is that something you've seen in the context of the IBC? Is that sort of a brewing market, or is that just not yet it's just not yet happened, and mostly foreign creditors are participating in the process?
I think it's not yet happened. There is a lot of talk about it, but I think it's still, when it comes to foreign creditors, they're still sort of waiting and watching and seeing how things pan out. That there is, I understand some actions have started, but it's still fairly low. But I think this is something that will increase.
Okay. Suharsh, unless you sort of have anything else to add on this, I think we've more or less reached the end of, I suppose, the key issues really to talk about on this topic. I don't know if we're going to have questions. I can't see them, at least. I don't know if you can, Montek. I mean, obviously, we're very happy to answer any questions, but otherwise, I think we can call the session to a close.
Sindhu, you can go to the Q&A if you want to view at the right side of your screen. After feed, you will see Q&A. So anybody who has a question can put in a question there and ask you. So you can keep replying. Also, we have a launch session at your left side, reception, sessions, and then launch, extreme top right, third one. So if you go to the launch, we have tables ready there. So after the session is over, I would request you all, if you have any discussions to go forward from here, you can also be there. However, we are willing to extend the time for you. No issues on that as well. Yeah, am I clear?
Yes.
So in the launch, you can have interactive and a very good session there as well. However, your session's really going on well, you can continue with the Q&A. Whatever you want to discuss further beyond this, please go ahead.
I think Vivek will start charging us his hourly rate to go beyond 1 p.m.
He is most welcome to charge you, Montek. He's most
No,
welcome to charge you.
I can't afford him. Ankit is the corporate here. Yeah, he will engage as needed. No, but I think
In fact,
frankly, we kept the speakers for
I have
2
a lot
hours.
of yes, your session was lengthy, but it's very interactive. I've also learned today that your interactive session is like, I'm trying to compare it with the other sessions. It's much more better because there's a lot of interaction happening. And we are the first ones to try AirMeet platform here like this and training simultaneously. So please understand our limitation also. You are giving us speakers in the morning to be added, right? So if they are adding in with the participant link, or they'll only show in the attendees. They need to log in from a fresh link of a speaker. That also from a laptop or a connection. Most of you know it, some of us don't know it. So we still learn. Please, over to you, guys. Please continue.
Thank you.
I think the reason is that you got the general counsel and the funder, so the expert and the lawyers are behaving properly. So I think that's the
Exactly.
I also practice as an advocate in Supreme Court. I work with Gujarat. For the time being, my baby is small, so I'm just attending on certain things. I'm a senior advisor to Indian National Bar Association. This is Vinakshi Singh. And I do a lot of legal awareness camps throughout India, pan-India level with my student section. And I do women empowerment projects as well. So
wonderful.
I am on the
really
other side. So, yeah. Thank you so much. Unless we have, I think we have something coming from Sindhu and Montek. So please carry on.
No, actually, I was just about to thank everyone for the session. I think it was. Thank you everyone for coming together on a short notice, and it was I thought it was a very interesting conversation, and I learned a lot from listening to everyone. I'm sure Sindhu feels the same way. It was a fantastic discussion, which we had the pleasure of moderating today. Um, Nothing from our side, I think nothing else. Like I said, we've already kept the panel for 2 hours. Vivek had just woken up. He still hasn't slept from last night. It's very, very early in London. And Ankit has pressing matters, including the ones we're discussing with us today, to go back to. So I just want to thank everyone, and thanks INBA for having us on board for this session. I'm sure there'll be a recording which we'll, I'm sure, share with our database and groups. Thank you very much to everyone, and look forward to staying in touch and for talking to you all soon.
Thanks a lot to FTI, especially to Montek, Sindhu, Vivek, and Ankit. It was lovely having, and to the two others who are missing from our screen now. So, and would love to have you guys in the launch. We can have a conversation there. Please click on the third button on your left side, and all the recording. It was live, showing live. It will be available. We'll send it to you through the link, but please give us some time. We've been struggling with it since yesterday. We have one more day to go on. So accommodate us with the time as well. And
Sure.
we have international speakers. We have wonderful sessions starting at 4 o'clock onwards. Again, international guests are going to be participating there. And even the member parliament from UK will be joining us today soon. We have people from the ministry joining us today again. So it was really nice having you all. Thank you so much. And the video recording, you yourself can go and click on the link and view it there. All the speakers can see it.
Great.
Thanks a lot.
Thank you, Meenakshi.
Thanks a lot.
Meenakshi, probably have to end this session because it doesn't allow us
Yes,
to go to the mouse.
I'm already doing it. Yes, I'm ending the session. It'll take some